In Suresh versus State, represented by Inspector of Police, Supreme Court allowed the appeal and acquitted the appellant by setting aside the order of High Court, thereby releasing him from jail. The brief case of prosecution was that on 12 September 2008 at around 6 p.m., appellant caused death of his wife by pouring kerosene on her body and setting her on fire, which ultimately resulted in her death after a period of approximately 3 weeks in a hospital. Appellant used to reside in his house at Narayan Shetty Street, Tuticorin, with his wife and a 2.5-year-old son. Mother-in-law and father-in-law of the appellant used to reside in the street next to Appellant Street. On the fateful day, that is on 12 September 2008, when child of the deceased was crying, deceased called her mother to pacify child and child was taken away by mother to her house, which was in the neighborhood. Meanwhile, prosecution witness 1 and 2 were informed by neighborhood child that their daughter Sumati had caught fire. She was then immediately taken to a nearby hospital and then to another hospital and eventually admitted in a government hospital in Thoothukudi. At around 9:30 p.m., when police received information, PW9 reached the hospital and recorded statement of deceased. In her statement to PW9, deceased stated that she caught fire while working in a kitchen. She also stated that at time of incident, appellant was sleeping and when she screamed, appellant woke up and tried to put off the fire. On basis of this statement, general diary entry was made by police on 12 September 2008. Thereafter, on 15 September 2008, case of accidental fire was registered. On same day, PW15 sub-inspector visited the scene of occurrence and seized a kerosene can and matchstick. Before death of deceased on 18 September 2008, judicial magistrate recorded statement of deceased and statement was used by prosecution as dying declaration. In this statement, deceased stated before judicial magistrate that it was appellant who had put kerosene on her and set her on fire on 12 September 2008. Court said that there is no doubt regarding well settled position of law that a dying declaration is an important piece of evidence and conviction can be made by relying solely on a dying declaration alone, as it holds immense importance in criminal law. However, such reliance should be placed after ascertaining the quality of dying declaration and considering the entire facts of a given case. If a dying declaration is surrounded by doubt or there are inconsistent dying declarations by deceased, then court must look for corroborative evidence to find out which dying declaration is to be believed. This will depend upon facts of the case, and courts are required to act cautiously in such cases. The matter at hand is one such case. According to prosecution, this mahazar corroborates the dying declaration made by the deceased. However, veracity of this observation mahazar is itself in doubt. Apart from fact that there had been an inordinate delay in sending mahazar to court, witnesses PW5 and PW6 to the seizure of above articles were also declared hostile. Normally, when death is caused by burning through kerosene, smell of kerosene would definitely remain for few hours, said the court. However, smell does not weaken after some time. Since in present case, deceased was immediately brought to hospital barely within few hours of incident, if kerosene was involved, then smell of kerosene ought to have been there. Even the doctor who had examined the deceased immediately after incident states there was no such smell. Court noted that it had come on record that relations between the two families, that is, family of accused and family of deceased, had soured. In 2006, barely 2 years before the incident, appellant's brother had filed a criminal case of assault against the appellant's father in law and brother in law. In that case, PW2 and his son were convicted. Before the trial court as well as the High Court, appellant had tried to unsuccessfully contend that dying declaration of 18 September is an afterthought of deceased and deceased made such a statement on being tutored by PW1 and 2. Court said we are not in a position to give any definitive view on this aspect, but considering other evidence on record, possibility of what appellant is suggesting cannot be ruled out. Thus, in our considered opinion, in spite of a dying declaration here, for the reasons above, total reliance on it would be misplaced. Consequently, appellant deserves to be given the benefit of doubt.